So if everything is okay, we'll start. Shall we start? Very good. Good afternoon. So we are talking about remuneration, right? So before we are discussing about remuneration, in yesterday's class, we studied about Schedule 5, Part 1. Why? Because remuneration situated in Schedule 5, Part 2. Schedule 5, Part 2. Before we understand Part 2, we have to understand Part 1. Talks about appointment of directors. Not not about appointment of all directors, appointment of managerial persons. Who are managerial persons means those who involve in the day-to-day affairs. The WTD manage. The crucial difference between MD manager I have already told. Manager need not to be a director of the MD director. Whether he will put in rotation or not depends on the recruit agreement contract and all. These are the points we discussed, and schedule 5 part 1 appointment completed, right? So what is meant by satisfaction of schedule 5 part 1? Schedule 5 part 1 satisfaction means few conditions are there which you need to satisfy. First one, no imprisonment, not even a single day, and no penalty which is greater than or equal to 1000 under some mentioned acts. Few acts are there, 16 acts are there. According to that 16 acts, you must not be penalized or you must not be imprisoned. Forget about period. Why? Because irrespective of the period, what matters is imprisonment. Whether you underwent imprisonment or not, that is the only deciding criteria. How many days you underwent imprisonment, it is material. 1 day, 2 days, 6 months, nothing. Even if you underwent imprisonment under the 16 acts, you are not in compliance with Schedule 5, Part 1. That is one point. Second one, no detention under one act. What is the name of the act? Okay, మీరు పోసారులేండి కాఫీ ఫుల్ ఫామ్ కాఫీ పోసా ఫుల్ ఫామ్ Conservation of Foreign Exchange and Prevention of Smuggling Activities Act. So, very good. So, according to that act, should not be detained. That is number 2. Number 3, age-wise restriction, but this restriction, but the power has been delegated to members. Central government nowadays delegated to members. So what is the exact rule is, if the age is not in between 21 to 69, that is age is 70 or more, then for the appointment of that person as MD or WTD or manager, actually you need to take CG approval. But currently in 2017, okay, amendments came 2017, CG delegated that power to shareholders itself. So if you are okay with that kind of appointment, so if you are planning to appoint MD or manager or WTD, a person who is aged more than 70 or more, then it is okay. If you okay with, if you pass with, if you ratifies the appointment, or if you agrees for the appointment by passing which resolution? Special resolution. Okay, actually CG delegated the authority to shareholders itself. That is third point. But anyway, 4 points are there. Out of the 4 points we have to study. Last point is what, ma? Resident of India. Okay, these are the 4 points. So if you satisfy these 4 points, you set to be satisfy Schedule 5 Part 1. Schedule 5 Part 1. And in order to consider a person's candidature or person's profile for the appointment of MD or WTD or manager, that person should not be suffering with any sort of disqualification. Disqualifications you already very well know, which you have studied under section 164. But for MD, WTD manager, 2 more additional disqualification points are there. Out of the 2 points, 1 point is what? That person should not entered with composition agreement with the creators or should not suspend payment to creators. That is 1 point. And second point is conviction period more than or equal to 6 months. So it is indicating your administrative inefficiency. That's why for that role you are unfit. That is what Companies Act is saying, not me. So these are the points which we studied in yesterday's class. So now we are going to start Schedule 5 Part 2 Remuneration. Uh, did I give any sort of introduction to remuneration? That's it. 11, 10, 5, 3, 1, nothing. So we'll start on a fresh note. Very simple, ma. Let's take a page. Listen. Very simple. So, but students will confuse a lot in this remuneration topic. So that is why paying attention to the core is very important. Okay, pay attention. So I think visible. Okay, right. So now we are talking about Schedule 5 Part 2. Schedule 5 Part 2. ఓకే, ఎవరైనా మాట్లాడుతున్నారు? నేను మళ్ళీ చెప్తున్నాను, దయచేసి క్లాస్ జరుగుతున్న బై వాట్స్ ఎవర్ రీజన్ మాట్లాడకూడదు. దయచేసి డీసెన్సీ, డిసిప్లిన్ కన్సిడర్ ఇట్ యాజ్ అ రిక్వెస్ట్. ఓకే, థ్యాంక్ యూ. So Schedule 5 Part 2 I am talking about. Schedule 5 Part 2, which talks about appointment or remuneration? Remuneration. Then Part 1 talks about, which we already completed, appointment completed. Now we are into discussion of Part 2, Schedule 5 Part 2. Then remuneration. Don't write anything, I'll give time for writing purpose and then you can copy. So Schedule 5 Part 2 talks about remuneration, which is allowable for directors. So exclusively the schedule talks about remuneration payable to managing directors or executive directors, MD, WTD, manager, their remuneration. So first of all, there are 2 sections. In the Schedule 5 Part 2, how many sections are there? 2 sections. Section 1, Section 2. Section 1, Section 2. Section 1 talks about companies having adequate profits. Companies having what? Adequate profits. That is, company is financially okay to pay remuneration to managing directors, MD, WTD, manager. Okay. When company is financially okay, company is having adequate profits to pay the remuneration, then whatever the mechanism that is there in section 197 of Companies Act 2013 can follow. 197. Sir, what is the mechanism stipulated under section 197 of Companies Act 2013? 197. Very simple. It is capping maximum remuneration payable to directors. Maximum remuneration payable to directors. This is the cap. 11% of net profits. How much? 11% of net profits, including all directors. I'm not differentiating between managing directors, executive, non-executive, independent, whoever they may be, including all directors. So they can't occupy how much share? More than 11% share in the net profits. Remaining should be distributed for dividends, reserves and all. Okay. So maximum 11%. Maximum how much? 11%. Sir, MD is there for the company, sir. He is having the substantial powers. Actually, due to the hard work underwent by MD, managing director, so company is able to achieve this much profits. So major credit should be given to MD, sir, managing director. Due to his efforts only, company is currently in this profitable position. Then suitable rewards should be given to MD. How much means not more than 5. That means there is a maximum cap for the remuneration of MD also. How much is the maximum cap? 5%. How much? 5%. Single managing director. Sir, multiple persons are there. Multiple persons means don't be in a confusion that multiple managing directors. Why? Because multiple managing directors not allowed. Joint MD allowed. I think I have already communicated this point. Okay. Multiple MDs means multiple managers who are looking after the administrative activities of the company, like executive directors, managers, multiple whole-time directors, MD, joint MDs, like that. Okay. So then maximum 10 percentage. 11 percentage is the ultimate thing. Within that 11 percentage, sublimits are there. I am talking about sublimits. Don't be in a confusion state that okay, 11 plus 5 plus 10, nothing. In this 11 percentage, 5 percentage is a sublimit. 10 percentage is a sublimit. Whatever the percentages which I am going to discuss now, these are all sublimits in this 11 percentage. Are we clear? So 11 percentage is what? Maximum cap on the remuneration payable to all directors of the company, whether they may be managing director, non-managing, independent, non-executive, executive, everybody. 11 percentage is the maximum cap. Okay. 5 percentage is the maximum cap for MD remuneration. Sir, why we are talking about specifically MD? Why? Because he is having substantial powers and he is responsible for the profits and losses. That is why there is a exclusive sublimit for MD. How much is the exclusive sublimit, ma? 5 percentage. How much? 5 percentage is the exclusive sublimit, not beyond 5. Next, sir, say for example, multiple MDs are there. That means multiple managing persons are there. MPs and them. Multiple managing persons are there. For that multiple managing persons, not beyond 10 percentage. Not beyond 10 percentage. That means 10 percentage is the maximum cap. 10 percentage. Okay. Next, 1 percentage and 3 percentage sublimits are there. Listen, what is this 1 percentage and 3 percentage means? 1 percentage for non-executive directors, and companies having MD. That means companies having administrative personalities. Okay. 3 percentage is for non-executive directors if company is not having any managerial staff. That means no MD, no manager, no whole-time director. Why we have increased the limit? Understand the logic. If there is no MD, manager, whole-time director, the whole workload should be discharged by non-executive directors only. They are working more. Being they are working more, you have to pay more. That is why 3 percentage is allowed. For non-executive directors, how much allowed? 1 percentage. Unless otherwise stated, for non-executive directors, how much is allowed, ma? 1 percentage only allowed, not beyond that. But here we are allowing 3 percentage. Why? Because the company is not having managerial personnel to discharge the functions of the company. So in one or other way, non-executive directors are the responsible persons to discharge those functions. That is why 3 percentage limit. Otherwise, 1 percentage only. Why? Because by default, company is having MDs, right? By default, company is having managerial personalities, MD or chairman or whole-time directors, managers. Somebody will be there to look after the activities of the company. Such mechanism is not there, then only for non-executive directors remuneration will be hiked up to 3 percentage. Otherwise 1%. So I think now you are able to understand the limits as well as sublimits. So total how much ma? 11 plus 5, 16, 16 plus 10, 26, 26 plus 1, 27, 27 plus 3, 30. Total 30% of net profits directors can bag away. That's it. Am I right? Why can't we add these all these limits ma? Is this the correct way? No, 11% is the maximum limit and you can't draw more than 11% of the net profits of the company in the name of managerial remuneration. I mean, director's remuneration. Out of that 11% sublimits. 5 is there, 10 is there, 1 is there, 3 is there. Kindly observe 5 and 10 both are not applicable into single scenario. Company is having single MD and multiple MD parallelly. Yeah? Either the company will be having single MD or the company will be having multiple managerial persons. So 5 and 10 not applicable to single case. Either 5 or 10. So these are the limits stipulated under section 197 of Coffee Bosa Act. Which act ma? Companies Act we are talking about. Section 197 is stipulating these maximum limits. 11, 10, 5, 1, 1 for non-executive directors and companies having managerial mechanism. Managerial mechanism. In that case, for non-executive directors, 1%. Non-executive directors, how much percentage? 3% if there is no managerial mechanism. 1 and 3 clear? 11 clear kada? Total limit. 10? 10 and 5 also very clear. Why? Because 10 and 5 are not applicable to a single company parallelly. So 5, there is only one MD. 10, multiple managerial persons. Okay. So these are the limits stipulated under section 197. So when you are going to follow section 197 means company is having adequate profits. Company is having what? Adequate profits. Then we will follow this mechanism. Which mechanism? This 11% mechanism and all. Sir, companies shareholders are in a mood or in a will, they are willing to increase these limits. They wish to increase this 11% to 15%, 18%, 20% and all. They can do so by passing special resolution. Previously, there used to be ordinary resolution, ma. So shareholders can increase these limits by passing ordinary resolution, but amendment came, and nowadays, which resolution is required? Special resolution is required. If any old scanners, old author books mentioned ordinary resolution, they are also correct at that time. But now amendment is there, so kindly correct. It is special resolution. Okay. So some students will be there. They will refer to multiple author books. Is nothing wrong in referring and all. You can refer whatever book you may wish to. But kindly observe the amendments. Law is a dynamic subject. It will keep on changing. Law is not static. Okay. So don't compare with current rules and regulations with previous rules and regulations. So which resolution is required? Shareholders required to pass which resolution? Special resolution. Okay. Due to amendment, previously it used to be ordinary resolution. OR is sufficient, but they modified it to special resolution. That is the point. Are we clear? So this is situation when the company is having adequate profits. The situation stipulated under section 197 of Companies Act 2013. The point. Now, crucial thing is we have to discuss section 2. That means companies not having adequate profits. So, so this is scenario 2, section 2. No adequate profits. That means company is not financially well enough to pay off the remuneration to directors. In that case, how we should follow remuneration methods and all. ఏంటమ్మా తిట్టుకుంటున్నారా? సడన్గా కళ్ళు మండుతున్నాయి బాగా. ఎరా మీలో ఎవరికైనా చేతపడొచ్చా? No adequate profits. No adequate profits. No adequate profits. That means company is not financially well enough to pay off the remuneration. Then you need to follow this mechanism, effective capital mechanism. Effective capital mechanism. Sir, what is effective capital mechanism? So whenever the company is not having adequate profits, then directors will be classified into two lists. So list A, list B. A, list B. So first of all, list A. Second, list B. So second is what? List B. Sir, which directors fall under list A and list B? Simple. Managerial personalities. That means executive people. Directors who are attending to day-to-day activities of the company, who are administering the affairs of the company. Managerial people fall under list A category. That means obviously those people who will not fall under list A will come under list B. In other words, non-executive people. In other words, which people ma? Non-executive or non-managerial people will fall under list B category. Okay. So do you really understand which directors fall under list A category and which directors fall under list B category? So when we need to differentiate directors under list A and list B, companies having not adequate profits. In that case, we have to follow this mechanism, list A and list B. First of all, you have to differentiate. And depending upon the effective capital mechanism, you need to pay the remuneration to directors. Very simple. What is effective capital? I'll tell you. There is a formula to calculate effective capital and all. Paid up share capital. Tell you. Okay. So first of all, effective capital you have to determine. Say for example, your effective capital is negative to 5 crore. That means your effective capital is less than 5 crore. It may be negative also. Sometimes if the company is suffering with lot of accumulated losses. What are accumulated losses? Losses which are coming from past years. So if company is suffering with lot of accumulated losses, the effective capital is negative. That is not a surprising thing. Lot of sick companies is having negative capital. So this is not a very surprising thing in reality. So if your company's capital is 5 crore below, 5 crore below means 4, 3, 2, 1, 0, negative also. Sometimes it may be negative also. So if your effective capital, which mechanism? Effective capital. If your effective capital is negative to 5 crore, up to 5 crore, negative to 5 crore, you can pay up to 60 lakhs. You can pay up to how much, 60 lakhs you can pay. These limits are per director per annum. Don't think that how we should adjust 60 lakhs to all the managerial directors. No, for one person I am talking about. Not monthly, it is annually. Per director per annum. Per person per annum, like that you can remember. Okay. Sir, our capital is 5 crore to 100 crore. Next 84 lakh you can pay. Okay. Huh? Anything to say? ఏమన్నా చెప్పారు నాకు వినబడలేదమ్మా. Of course, it is 60 lakhs or 84 lakh, everything per person per annum, per director per annum. Not monthly, it is annually. Okay, na? Very good. So, 100 crore to 250 crore, 120 lakhs. Ma. This is also same, per director per annum. Per director per annum. Okay, next. Greater than or equal to 250 crore. Then listen, 120 lakhs plus 0.01 percentage of the capital which is beyond 250 crore. 0.01 percentage of the capital which is beyond 250 crore. This is the limit. These are the limits. These are the limits. Are we clear? We can increase these limits. That is a different thing, I'll tell you. Okay. So this is the effective capital mechanism. This is which mechanism? Effective capital mechanism. If your capital is up to 5 crore, 60 lakh per director per annum is the limit. If your effective capital is 5 crore to 100 crore, 84 lakh per director per annum is the monetary limit. If your effective capital is 100 crore to 200 crore, 250 crore, sorry, 250 crore, then it is 120 lakh per director per annum. If your effective capital is more than 250 crore, then 120 lakh plus 0.01 percentage of the capital beyond 250 crore. That means if your capital is 350 crore, 120 lakh plus 0.01 percentage of the 100 crore. 0.01 percentage of the 100 crore. Like that we can calculate. Okay. So these are the limits as per list A. List A. What kind of directors will be situated in list A? Managerial person. That means these guys are working very hard for the growth of the company. That is why bigger limits are there. 60 lakh, 84 lakh, 120 lakh, like that. Okay. For non-executive, that means list B. For non-executive, for list B directors, limits are simply by 5. Limits which are available to executive people, managerial people are there, no? Divide by 5. 60 by 5, 12 lakhs. Okay. 84 by 5, 16.8 something will come. 17 you have to take. Okay. 120 by 5, 24 lakh. 24 lakh. Here obviously 24 lakh plus 0.01 percentage of the capital beyond 250 crore. Same limits. But list B directors are hardworking, non-working, non-executive. That is why for these kind of directors, you can justify even though you pay less than list A directors. That is why divide by 5. So here it will be 60 lakh, 84 lakh, 120 lakh, 120 plus 0.01 percentage. And here 12 lakh, 17 lakh, 24 lakh, 24 lakh plus 0.01 percentage. So these are the limits. These are the limits. Okay. I think everybody clear? List A applicable to whom? List B applicable to whom? List A managerial persons. List B non-executive persons. Non-executive persons. So this is the basic bifurcation. A and list B. So schedule 5 part 2. Part 1 talks about appointment. Part 2 talks about remuneration. And you have to bifurcate whether the company is having adequate profits to pay off the remuneration or not. On that basis, you have to decide the limits. Yes, sir, we are having profits. Then whatever the mechanism stipulated under section 197, you have to follow. What is the mechanism? Percentages, 11 percentage, 5 percentage, 10 percentage, 1 percentage, 3 percentage. But you can increase the limits by passing special resolution. Is allowed. Is allowed. Whenever you are having profits, And if you wish to increase the limits, you can do so. Sir, how many times we can include? It's upon to you. 2 times, 3 times, 4 times, 5 times, 10 times. As far as you are in profitable condition and shareholders are agreeing for your incremental remuneration, government or MCA or authorities are not having any sort of objection with respect to your remuneration. It's up to you and your shareholders. Depends. Shareholders are ready and willing to pay the money. Directors are ready and willing to accept the money. Authorities are also not having any problem. Second position. Company is not having adequate profits. Then which mechanism you have to follow? Schedule 5 part 2 stipulates one mechanism, that is effective capital mechanism. Effective capital mechanism. And according to effective capital mechanism, first of all you have to find out what is meant by effective capital. Okay, if your effective capital is up to 5 crore, some limit 60 lakhs is there. Likewise, 0 to negative to 5, 5 to 100, 100 to 250, beyond 250, 60, 84, 120, 120 plus 0.01 percentage of the capital exceeding 250 crores. So limits are how to follow that mechanism. And whenever you are following mechanism, I mean schedule effective capital mechanism, you have to first of all differentiate the directors who are executive and who are non-executive. List A applicable for executive, list B applicable for non-executive. Monetary thresholds for list A and list B are different. List A monetary thresholds are 60, 84, 120, 120 plus 0.01 percentage. List B monetary thresholds are 12, 17, 24, 24 plus 0.01 percentage. So these are the limits. And there is a small bifurcation applicable in list A directors also. So there is a bifurcation in schedule 2, I mean section 2, schedule 5 part 2 section 2, list A and list B. In that list A itself again two bifurcations are there. What are the bifurcations, or what is exactly the bifurcation is identifying professionally capable persons and others. Professionally capable persons means you are working in the company by virtue of your qualification and expertise, and you are not related to management or promoters group. You are not holding more than 0.5 percentage of the shareholding, and company administration is so far successful. You are not making any defaults to creditors, banks, financial institutions, debenture holders and all. You are satisfying all these conditions. Tell me the condition. For example, first of all, you are not related to promoters or management group, and you are working here by virtue of your qualification, not due to unnecessary pyravies or something else, not due to anyone's influence or else. You are working here under your qualification and expertise. You possess the required qualification, you are skilled. That is why you are working here. That means your education or your qualification or your experience is justifying your role. It is justifying your role. Simple example, ma. What is the Reliance online shopping website? Agio. Agio activities will be taken care of by Loka Ambani. Her name is what? Anant Mukesh Ambani daughter, Isha Ambani. Isha, correct? Na? Okay, I don't know the exact name. So she is taking care of the Agio directorship responsibilities and all. By virtue of qualification or by virtue of expertise, she is carrying that position. Huh? No, definitely she is related party. That is why she is holding that position. So those directors who are professionally qualified and they can justify their holding role. They are holding the role by virtue of their qualification, education, expertise. Okay, and they are not related to promoters or management group, and they are not holding more than 0.5 percentage of the shares, and administration is so far good. The company is not indebted or not defaulted to any bankers, public financial institutions, creators or debenture holders. Okay, so now listen, if the administration so far is good and you are not related and you are holding that position by virtue of your skill, not by anybody's influence or something else, and for you, for you, that means for those directors who are professionally capable, obviously they are working hard for the growth of the company, they will be under list A. So for these directors, incremental mechanism is bit different. So what is that incremental mechanism? Very simple. If shareholders passed special resolution to increase their remuneration beyond this so-called stipulated limits, that is 60 lakh, 84 lakh, 120 lakh, 120 plus something, 0.01 percentage, they can increase the limits. But till how many times they can increase the limits? Depends. It is depends upon the relation between shareholders and the so-called directors. Sir, 5 times they can increase it. 10 times they can increase. Yes. Your company is in loss, but 10 times, 20 times they don't increase. Hardly 2 times or 3 times or 4 times maximum. That too in exceptional cases they may increase. But actually Act what is saying is you can increase. We are giving power to you. You can increase by any number of times. For everybody, no. For list A people, that means managerial people, that too in managerial people, there are certain conditions for professional qualification. Then only unlimited revision, unlimited increment is possible. Shareholders are blind people or shareholders are having brain, right? So they don't increase like 10 times, 20 times, 30 times. They do consider the financial position of the company. If the remuneration which is going to be awarded to the directors is justifiable, then only they will also give. Okay, they don't give like a senseless person or something else. They do consider the financial position. By keeping that point in mind, they only revise the incremental position of the remuneration of those persons who are falling under list A subclassification 1, that is who are working with their professional capacity. In this managerial group also, some directors will be there who are not justifying their professional capabilities. That means, just like I said, they may be related to promoters or management. They might holding more than 0.5 percentage of the shareholding. Okay, next, their education or their qualification or their expertise is not justifiable to the position they are actually holding. For 22 years or 23 years, you are becoming MD of some 1000 crore company means, in any other company, you are not qualified enough to carry that position. But being this company belong to your family group and all, by that virtue, you are holding that position. Okay, so for related parties, unlimited increment is not possible. Hardly you can increase up to 2 times by passing special resolution. How many times you can increase? 2 times. You can double the remuneration. 60 will become 120, 84 become 168. 120 will become 240. Like that, double you can increase. Not beyond that. Coming to list B. List B, what kind of directors will be situated in list B, ma? Non-executive directors. Asale company suffering with losses. These non-executive directors, like white elephants. What is meant by white elephant? Do you know? White elephants are good for nothing. The maintenance cost of white elephants much higher than normal elephant, and due to normal elephants also some use will be there. But with white elephants there will be no use. They are for attraction purpose or admiration purposes only. White elephant. White elephant means, say for example, you are having one BMW car which you purchased from Delhi market for 7 lakhs. Okay, it is a trending no, from last 2 to 3 years. So they do sell Benz cars, Porsche, not Porsche, but what Jaguar cars, BMW. They'll sell for pocket friendly price only you can get ma. But after purchase, you will come to know what are the exact defectives of the company. Why? Because purchasing a car is not at all a big thing. Maintaining a car is a big thing. Say for example, for 5 lakhs or 6 lakhs, you purchased Audi or Benz or BMW or Jaguar. You take the vehicle to service center. That itself, the if any components or peripherals are missing, average bill will be 2 to 3 lakhs. How much you spend for the acquisition of the car? 5 lakhs. How much you are investing for a normal repair? 2 to 3 lakhs. I am not saying for each and everything 2 to 3 lakhs they will incur. On an average, the repair cost, you can Google it. On an average, the repair cost is 2 to 3 lakhs. Then what is the use? Can't use it. In your house parking space, you can happily put that car as a showcase piece. White elephant. Good for nothing, but you have to maintain. Okay, so that is the situation. Like this here also, companies not having adequate profits to discharge the remuneration for normally hardworking people. Now these guys are coming, non-executive people, and they are also asking hike in their remuneration. How much you are giving? 12 lakh, 17 lakh, 24 lakh, or 24 lakh plus odd 0.01% is something that you are giving. That is not sufficient for them. They are asking hike. They are asking hike. For that hike, it is possible to give the hike, but again, special resolution is required. Up to 2 times hike only possible. Likewise, in the case of item A, professional capable directors are there. No, 3 times, 10 times, 20 times. That number of incremental time, that incremental mechanism is not applicable in case of item B. Hardly you can increase up to 2 times. Hardly you can double it, not beyond that. Previously, there used to be a provision. What is that provision exactly saying is, say for example, if you wish to give more than 2x remuneration, yes, it is possible. You have to ask CG permission. But the provision has been abolished. 2017 amendment only effective from 2018. The provision has been abolished. Nowadays, it is not possible for the company to or more hike rather than more than 2x remuneration. That is the point. Okay, so this is the monetary limits applicable in case of schedule 5 part 1. So this is entirely thing. Sorry, part 2. Part 1 talks about appointment, right? So schedule 5 part 1, part 2 is there. Part 1 appointment, part 2 remuneration. In part 2, section 1, section 2 is there. Section 1, if company is having adequate profits. Section 2, company is not having adequate profits. In section 2, 2 sections are there. List A, list B. List A for managerial directors. List B for non-executive directors or non-managerial persons. In list A, again, 2 classifications are there. Directors who are working with their professional expertise in professional capacity, others. Why to differentiate between list A directors in order to give incremental composition? For professional directors, you can give increment up to any number of times. If shareholders justify the increment, you can give. For others, you can't give more than 2 times. Okay, and here also list B, for them also not more than double, it is not possible. More than double, it is not possible. That is it. Clear? Now, this is schedule 5 part 2 remuneration. Just schedule 5 part 1 appointment. Yesterday we completed this process, right? These are the provisions, qualification, maximum. Do you remember this point? 5 years at a time, reappointment should be done only before 1 year. Only before 1 year. That means, okay, next one. Remuneration. Remuneration Schedule 5 Part 2. Just now I told Section 1, Section 2. Section 1, adequate profits, no profits. If adequate profits, pay according to Section 197. Max how much ma? 11%. Single MD or WTD 5%. Multiple MDs WTD 10%. Non-executive directors, no MD 3%. Non-executive directors, there is MD. Workload will be less for non-executive directors if there is MD. That is why only 1%. Workload will be high for non-executive directors if there is no MD. That is why 3%. Okay. Limits can be increased by passing simple ordinary resolution, previous rule, but change it to special resolution. Okay. So now which resolution is required? Special resolution. This is all about Section 1. Section 2, no profits. That means company is not having adequate profits. Now, item A. Item A, what directors? Managerial directors. Item B, non-managerial directors. If item A conditions does not satisfy, we will follow item B. What is the condition? Managerial, non-managerial. Okay. So, there is a subclassification in item A, those who are working in professional capacity. So, follow effective capital mechanism per person per annum. Negative to 5 crore, 60 lakh. 5 to 100, 84 lakh. 100 to 250, 120. More than 250, 120 plus 0.01 percentage of paid up share capital which is exceeding 250 crores. And this is for non-managerial, that means non-executive directors. Simply by 5, 12, 17, 24, 24 plus 0.01 percentage. Okay. For non-managerial directors, limits can be increased by double by passing special resolution. So this is the effective capital formula. Simple one. Paid up share capital plus security premium plus loans borrowed from outside persons plus reserves and surplus minus investments. This is not inventory, investments. Minus accumulated losses minus preliminary expenses. If anybody wish to copy, you can copy. So effective capital formula is what? Paid up share capital plus security premium plus loans borrowed from other banks, financial institutes, outsiders, reserves or surplus if any. Generally reserves or surplus won't be there. Why? Because you are suffering with losses. So minus investments minus losses minus preliminary expenses. Professional capacity means what? Professional capacity means you are not related to promoters or directors, simply management, and not holding more than 0.5% of shares, and you are having qualification and expertise, and company has no default in repayment to banks, financial institutes, debenture holders, creditors. Debenture holders, creditors. Okay. Item A, within the limits. Item A means managerial or non-managerial? Managerial, within the limits. Board resolution is enough. No need to ask anybody's permission. Why? Because the mechanism stipulated in item A, schedule 5 part 2 only. No need to ask anybody's permission. If you wish to increase the limit, SR is required. Which is required? SR is required. In that item A, you are increasing limits for capable persons. No limit. You can increase up to any extent. You are increasing for others only 2x. Only you can double it. For item B, SR is mandatory. Special resolution is mandatory. If anybody screen is not visible, now it is visible. Item B. So SR is mandatory. Special resolution mandatory plus prior approval from, if any default existed, you have to take permission from that bank or financial institution or debenture holders or creditors. Prior approval is required. And 2x limited. 2x limit you can increase special resolution. More than 2x have to take CG approval. Rule abolished. Currently such rule is not there. So if anybody is paying more than what is allowed according to this mechanism, it will be treated as you owe to the company. You have to refund the money to company. You have to refund the money to company. Otherwise, penalties will be levied for the officer in default as well as directors also. Monetary penalties will be levied. Okay. So this is the total scenario. So do you really understand Schedule 5 Part 2? So this is the thing we have written. So say for example, Now you please tell me, I'll write. I don't know anything. How to tell me, then I'll copy. What is the schedule 5 part 2? I'll take fresh page. Schedule 5. Can I ask any specific persons? You are sigging రే స్పెసిఫిక్గా అడగొచ్చా? ఎందుకు సార్ లేత కాన్సెప్ట్ ఇప్పుడే నేర్చుకున్నప్పుడే ఇబ్బంది పడిపోతూ ఉంటారు. Schedule 5 part 2. Part 1 talks about appointment. So we are talking about part 2, which is remuneration. Now tell me, how many sections are there? 2 sections. So section 1, section 2. Section 1, adequate profits. No adequate profits. Tell me. Adequate profits are there. You have to follow mechanism stipulated under section 197. What 197 is saying? 11% of net profit. This is overall remuneration to directors. Overall remuneration, total. Managerial, non-managerial. Everybody will be included in this. 11% of net profits. You can increase. 11% you can increase up to 15, 18, 19, 20, 22, like that you can increase. But which resolution is required? Special resolution is required. Sir, can we increase up to 40%? It's up to you. Why? Because you are having what? Profits. You are having adequate profits. So as far as you are inconsistent with the expectation of your beloved shareholders, they may award with anything. Okay. So overall remuneration to directors limit is 11%. So in this 11%, are there any sublimits? Yes. 5%. Max 5% should be given to MD if only one person, managerial person is there. He might be MD or WTD or manager. Next. 10%. Multiple MDs, WTDs, managers. 10%. Next. 1% limit for non-executive directors. Non-executive directors and managerial persons are there to supervise the administrative activities of the company. Whenever there are managerial persons to supervise the mechanism, then non-executive directors workload will be high or low? Low. That is why 1%. Next. Same case, but no managerial person supervising mechanism. That is the thing. These are the limits under 197. 197. Companies having adequate profits. Very good. This is section 1 and this is section 2. Very good. Now tell me, what is about companies not having adequate profits? Now tell me. List A, list B. List A, list B. List A, in again list A, there is 2 classes or bifurcation is there. We will do bifurcation in list A on what capacity? Professional capacity. So whether they are carrying their chair due to their own talent or any other influences will be there. You have to differentiate. Let's differentiate at a later point of time. First of all, list A and list B. Executive, non-executive. Executive, non-executive. Now tell me, list A limits. I don't know how you will give remuneration in case of companies not having adequate profits. We have to follow section 197. No, we have to follow effective capital mechanism. In order to follow 197, there are no profits. There is no profit. 11%, 10%, whatever the percentage it may be, nothing will be given to directors. So that is why you have to follow which mechanism? Effective capital mechanism. Mechanism? Effective capital mechanism. So, effective capital mechanism. Tell me, I don't know what is effective capital or something. Do you really understand effective capital formula? Formula. Tell me. Paid up share capital plus security premium plus loans borrowed from outside persons plus reserves or surplus if any minus investments minus accumulated losses minus preliminary expenses. This is the formula to calculate effective capital. Okay. So congratulations. Okay. Effective capital. Now limits, monetary limits, tell me. Negative to 5 crore. That means up to 5 crore. Ma. If 5 crore is there, exactly 5 crore is there, you have to go to second slab. Up to 5 crore. Next. 5 crore to up to 100 crore. 100 crore to up to 250 crore. Greater than or equal to 250 crore. Greater than or equal to 250. For list A directors, remuneration is 60 lakhs, 84 lakh, 120 lakh, 120 lakh plus 0. So this is the remuneration allowable to list A directors per director per annum. Per director per annum. And what is the remuneration allowable to list B directors? 12 lakh, 17 lakh, 24 lakh, 24 lakh plus 0.01 percentage of the paid up share capital which is beyond 250 crore. That is the thing. Okay. Now, these are the monetary limits. These are the monetary limits. Now, let's talk about differentiation existed in list A. Directors who are holding their position by their professional capacity, others. Okay. So, this subclassification, directors who are holding their positions due to by virtue of their professional capacity. Okay, these are the 2 points to classification. Okay, so first one, in order to qualify in this category, what are the conditions? Tell me. He must not be related to promoters or management, must not hold more than 0.5 percentage of the share capital, having qualification and expertise which is justifiable for the position he is holding in the company. Fourth one, the company should not be defaulted in repayment of loans to banks, financial institutions, creditors, debentures. That is a different thing. Okay. Now tell me, for professionally capable persons, is it possible for the shareholders to increase the limits? Yes, by passing special resolution, you can increase the limits up to 5. 5 times. Did I say so? N number of times they can increase. But shareholders are having common sense. That is why they don't increase like 20 times, 30 times, 10 times like that. By looking at the financial position of the company, they do consider how much they should increase. So, but act is having no restrictions upon the incremental limit. Okay, 2 times, 3 times, 4 times, 5 times, anything is possible. Why? Because these guys are hardworking and justifiable persons to hold their position. For others, max 2 times. You can double their remuneration, not beyond. Sir, we didn't allow them, sir, to draw more than remuneration, to draw more than double limit, sir. But they are drawing, sir. Why? Because administration, bank accounts, passwords, everything will be contained with the directors only, no? Kind of crucial data will be vested with shareholders or directors? Obviously, directors. So they are transferring more than what is allowed according to the act. Then it will be considered as loan. It will be considered as you owed money to the company. You have to refund the money. Penalties also will be levied. It's a different thing. No one will draw like that. So if anyone draw, they have to pay the penalty and they have to refund the excess remuneration. Okay. Next, for list B, max limit is how much, ma? 2 times by passing special resolution. There used to be a provision which is facilitating for list B directors also to increase the limit beyond 2 by asking CG approval and all, but the rule has been currently abolished. It is not in force currently. That is why max 2 times it is allowed. Beyond that, not allowed. It's all about remuneration payable to directors. It's all about total remuneration payable to directors. Okay. So I think everybody got the clarity. Huh? Not copied. Huh? You need time to copy? Okay, right. Carry on. Doubt? Huh? Hundred percent special రాయలేదా నేను 2x by passing special ordinary resolution used to be there, but it has been modified. Currently special అయిపోయిందా అవ్వకపోతే అనుకో పంపించారమ్మా ఫర్ ప్రింటింగ్ అండ్ వచ్చేసినాయి కూడా వచ్చినాయి బ్యాటరీ యువర్ మ్యాక్ విల్ చేస్తా ఒకసారి ఆ స్విచ్ షాక్ కొడుతుంది జాగ్రత్త లేదా okay ma so this is all about remuneration. Next, powers and directors will be there. Powers and directors. So whatever the topics we learned, I have summarized this one, not required. Difference between MD, WTD, manager. I think I have already communicated these differences. MD, who is having substantial powers. Why? Because board of directors is the ultimate authority. That is a shareholders is the ownership. Owners, that is a different. For administrative point of view, board is the superior power. But each and every person in the board can't participate daily in the regular affairs of the company. That is why they will appoint one other person to supervise the regular activities of the company, and they do delegate the substantial powers to that person. That person will be called as MD, managing director. Okay, so managing director is a director who is having substantial powers of the company, and he is subordinate to the board. Subordinate to the board means according to the board instructions only he has to work. Why? Because substantial powers MD is having, that is a different thing. But who gave that substantial powers to MD? Board only gave. మీకు అర్థం కాలేదా? Listen. Who are the real owners of the company? Have clarity point, right? But shareholders can't run the business. That is why one body, one regulatory body, administrative body should be there. That body is BOD, board of directors. Multiple board of directors will be there. That is a different thing. But out of that multiple board of directors, there must be some directors, some persons who will look after the regular affairs of the company. Why? Because for each and every decision, if you are going to ask each and every director's approval, administrative activities won't be proceeded further. That is why board will appoint one person as MD and delegate substantial regulatory powers, I mean routine powers. So in order to run the business in the best interest of the shareholders, he is having substantial powers to run the business. That means in regular course of business, he is not supposed to ask anybody's permission. This point is causing unnecessary confusion to lot of students, saying that okay, MD is the superior authority. No, MD is not the superior authority. MD may be the superior authority in the regular course of business, but not the superior authority beyond BOD. Why? Because MD is having the powers. Who gave that powers? Board of directors only gave that powers. Board of directors entrusted the powers with this person. Why? Because say for example, listen, 14 directors are there in a company. In order to take one routine decision, what is meant by routine decision? Say for example, you are going to purchase materials, raw materials. So you have given POs to all the suppliers. You are having 100 suppliers. You are having 100 suppliers. Sir, in reality also 100 suppliers will be there. Why not? More than 100 will be there. You know, HP laptop company, Hewlett Packard. Hewlett Packard is having 2,53,000 plus registered suppliers. So Hewlett Packard, HP company is having the privilege to buy the peripherals from all these 2,53,000 plus suppliers. It may give order to anybody in that 2,53,000 people. All our businesses, I'm talking about worldwide, not in India. I'm talking about global business. So 2,53,000 peripheral supplying businesses have been registered with HP, saying that you give offer, we are ready and willing to supply raw materials for you. Raw materials for computer means what? Don't you know the raw materials? So it may be display screens, motherboards, circuits, whatever it may be. Okay. So 100 is not a big deal. 100 easily you are having. So say for example, company is planning to purchase 100 tons of raw material. How many tons? 100 tons of raw materials. Company gave POs to 80 registered suppliers. PO means purchase order. So depending upon the quotation and all, we will select one supplier or two suppliers or three suppliers. If we select four suppliers, 25, 25, 25, 25 will purchase. Why? Because we need 100 tons. Or you may select only one supplier for the whole supply of 100 tons. Depends upon your routine mechanism, how you are going to do the business and all. It's up to you. So now listen, company is planning to purchase raw materials, send quotations for everybody. In return, replies received from 80 suppliers. Everybody is ready and willing to purchase, ready and willing to supply raw materials to the company. Now, board of directors, 14 board of directors conducted a meeting. The agenda of the meeting is from which supplier we have to purchase raw materials. Is it a that much crucial decision? In order to take that routine decision, convening board meeting is required. If a board of director attend for one board meeting, you have to pay sitting fee. You have to pay to and fro charges. You have to pay for accommodation. So for 14 members, minimum to minimum 1 lakh you have to pay. Why? Because sitting fee only nowadays 40,000 to 60,000 is their average board of directors sitting fee. One meeting sitting fee 40 to 60,000 is there. To and fro flight charges, accommodation in hotel and all. You can't place a director in OYO room, right? So you have to take on 3-star hotel room and all. So at least 60 to 70,000 you have to pay for one director. You have to spend on one director. 14 directors, how much ma? 70,000 into 14 means 7 lakh, 9 lakh 80,000. Around 10 lakh you have to spend in order to convene one board meeting. And what kind of decision you are taking? From whom you have to purchase raw material? Raw material purchase worth is 5 lakh. Plot twist is how much worth of raw materials you are purchasing? 5 lakh. So in order to take raw material purchasing decision worth of 5 lakh, you are spending 10 lakh for board meeting. Wow. Wow. Okay. So for these kind of routine decisions, convening a board meeting virtually or physically, it is not that much required. It is called overaction. That is why for taking routine decisions, board will appoint one person and board will delegate substantial powers to take routine decisions to that person. That person is nothing but MD, managing director. Okay. So managing director. So MD is a director who is entrusted with substantial powers of the management. Key feature, he must be a director. He has substantial powers. Powers can be by virtue of articles, board resolution or agreement. Whole-time director. Whole-time director is a director in the whole-time employment of the company. Key feature, he must be a director. Full-time employee may or may not have substantial powers. He is bound by the terms of employment like any other employee. Manager. A manager is an individual who is responsible for the management of the company, management of the whole or substantially the whole of the affairs of the company. Need not to be a director, may or may not be on the board, subordinate to the BOD, can have executive powers. This is the summary table. MD, whole-time director, manager. Must be a director. Yes, not necessary. Employment. May or may not be full-time. Must be full-time. Why? Because whole-time director, he has to spend whole time with the company. Full-time, manager. Substantial powers. This guy is MD is having substantial powers. WTD not having substantial powers. Manager. Why? Because at a time you can't hold manager plus MD. Either one person should be there. Subordinate to the board. Everybody is subordinate to the board only. This is not a big thing. Governing section 2 subsection 54 MD, 2 subsection 94 WTD, 2 subsection 53 manager. Sir, are we supposed to remember the section numbers and all? No. Important section numbers, try to remember. That's a welcoming thing. So there is no hard and fast rule that you must quote section numbers along with subsections and all. No. So eligibility criteria, approval, term of appointment, already we have covered all these rules. One person rule also we just completed. A company shall not appoint both MD and manager at the same time. However, a company can appoint both an MD and WTD. That's a different thing. Sir, I wish to have multiple MDs, sir. Not possible. You can appoint by the name of joint MD. Next, listed companies, SEBI LODR regulations you have to follow, listing obligations and disclosure requirements. So, you will know more about SEBI LODR regulations in Act. There is one law. Next topic is what? Powers and duties of directors. Powers and duties of directors. So, I think powers we can discuss tomorrow. Duties we can discuss now. Why? Because powers 3 subclassification is there in powers. 1. Specific powers of the board. That means these powers can be exercised only by passing board resolution at a board meeting. That means in order to execute these activities, resolution by circulation is not possible. There is a concept called RBC, resolution by circulation. Resolution by circulation means directors not actually convening a physical board meeting. They meet online and they will pass resolution by circulation. Offline also possible, postal ballot kind of thing. Say for example, board wish to take one decision. Resolution will be sent for all the directors to their registered addresses. To their registered addresses. The reply will be sent by the director to the company. By collecting all the responses from directors, voting will be conducted. How many directors are favorable for this resolution? How many directors are against to that resolution? Say for example, 10 directors are there. Directors are favorable. 4 directors are against to the resolution. Resolution said to be passed. Why? Because majority are okay for the resolution. That is RBC. Directors are not convening any board meeting, but resolution passed. This is what we call RBC. Red blood cell. RBC means what? Resolution by. So you are not actually convening the board meeting. You are passing the resolution by circulation. Sorry, this is RBC. For taking the decisions relating to these 11 activities, RBC not allowed. That means you have to convene a board meeting. Discussion should be carried on. Brainstorming session should be happen in the board meeting. Thoughts, ideas should be exchanged between the directors. Okay, so this is first one. Second one, matters that can be approved by RBC. That means in order to take decision regarding these 12 activities, you can take decision by RBC mechanism. That means no need to convene a specific board meeting in order to take these 12 activities, in order to decide these 12 activities. And powers requiring shareholders approval. That means the third one is their fourth point. In order to do these activities, BOD are not entrusted to do these activities. BOD has to take whose approval? So the 3 classifications are there. Time is around 4 to 4:05. That means 4:03 or 4:44 in this laptop. Okay. So duties we can easily complete. That is why 6 duties are there. That is why I thought to complete duties first day and powers tomorrow. What do you say? Or powers today, duties tomorrow? Both tomorrow. That option not given by me. Okay. Right. So simple ma. Duties are very simple. We can complete in coming to 3 minutes. Right. So part B, duties of the directors. Duties of directors. Duties very simple. Obligations which need to be discharged whenever you are acting as a director of a company. Means you are acting. If you are acting as a director of a company, there are certain obligations which you need to discharge. For every role, duties and rights will be there. Say for example, tomorrow you get married. As a husband, you are having some roles and regulations. That is duties. What kind of duties you are having? పిల్ల పిల్లల్ని స్కూల్లో జాయిన్ చేయడం, డైపర్లు మార్చడం, అంటే చాలా ఉంటాయి, ఇంకెందుకు అప్పుడేందుకు. సో each and every role is coming up with their own rights and obligations. At least, do you know the rights of being a husband? ఏంటమ్మా, ఏంట్రా, డ్రమ్మా? డ్రమ్లోకి వెళ్తావా? దట్ ఈజ్ ending the fate of the husband in a miserable way. Very unfortunate thing. Okay, drum is very high. Cooker is better, no? Cooker is better. Okay. వాళ్ళు ఉన్నారు, వీళ్ళు ఉన్నారులేండి అనుకోవడం ఏముంది. మొన్న ఒక ఇన్సిడెంట్ ఇక్కడే జరిగింది, హస్బెండ్ చంపేశాడు వైఫ్. అంటే జనరల్గా ఏంటంటే అంతేలేండి, ఇంకెందుకులే దీని గురించి డిస్కషన్ ఎందుకులే. భయం వేస్తుంది రామిరెడ్డి అన్నట్టు. First one is what my duties of directors. So this is a codified provision of directors' duties introduced in Companies Act 2013. First one, you have to act in good faith. You have to act in good faith. Okay. So good faith, you might have already covered Uberima 5 days, not Upma fried rice. Uberima 5 days. Utmost good faith. Utmost good faith. In contract, didn't you studied utmost good faith concept? Utmost good faith, Latin word Uberima 5 days. Okay. So example, contract of insurance. Contract of what? Whenever you are obtaining insurance, you must disclose all the material facts which will impact the decision of insurance. Sir, I am hiding something. I am concealing some details with respect to insurance policy. If I disclose everything, the premium will be high. That is why I am disclosing a few details and hiding few details. Then you are not acting with utmost good faith. Insurance company is having each and every right to cancel the policy at any point of time. But as per IRDA rules, the policy is not questionable after 3 years. There is a new provision, but you have to act with utmost good faith. There are certain cases like this. In this case also, director must act with good faith. That means director should not be engaged in what we call conflict of interest positions. So should not act like that. There are certain duties which need to be executed for directors. Or not out of the duties, first one is act in good faith. A director must act in good faith in the best interest of the company, its employees, shareholders, community, and environment. All these names can be substituted by a single one: stakeholders. Simple. Okay. Second one, exercise duties with due care. Yes, very good. Exercise the due and reasonable care, skill, diligence, exercise independent judgment. Director should act like a person who is having bare minimum common sense. That's it. You are acting with a person who is having minimum common sense. It is said to be you are executing your duties with due care. That is the thing only we require. Okay. Beyond common sense, nothing more. Third one, avoid conflicts of interest. You should not involve in such kind of positions. If a situation is causing conflict of interest, say for example, one of the supplier offered some bribe, saying that if you purchase goods, say for example, you are an MD, you are having substantial powers to procure raw material for the company. No need to ask anybody. You are having that substantial power. Who gave that powers? Board gave that powers. One of the supplier, by knowing this thing, so offered some bribe, saying that you purchase raw material from my company for coming 2 to 3 months or coming 3 months. I'm going to offer this thing. Position is unnecessarily causing conflict of interest. You must not indulge in that kind of activity. So a director must not involve in situations where there is a direct or indirect conflict of interest with the company. Of course, it is a conflict of interest, no? Conflict means there is a what we call conflict means like godava. There is a fighting between interest of personal interest and company interest. He is offering some bribe, personal interest. You have to act in good faith, company interest. So you must not involve or you must not indulge in that kind of situation. That is what act is saying. That is fourth one. That is third one. Fourth one, you should not achieve any undue gain. Undue gain means the gain for which you are not eligible. Undue gain is the gain for which you are not eligible. Say for example, you are drawing your salary. You gain only. Why? Because you are eligible for your salary. Undue gain means the gain for which you are not eligible. So you must not achieve any undue gains or undue advantages for yourself or relatives, associates or partners. If any gain is made, it must be repaid to the company. Simple thing. Excess of remuneration also I have already told the same thing. If any excess remuneration drawn by you, you have to refund it. Not assign the office. Assign means transfer. What is meant by assignment? Transfer. You must not assign your office. Why? Because by simply trusting you, they are appointing you as a director. So it is your responsibility to execute the duties by using your skill and judgment. Why? Because your skill and judgment and third party skill and judgment is entirely not same. There is no hard and fast rule that skill and judgment must be the same. Say for example, a person is having 23 years of age. Other person is also having 23 years of age. Is there any hard and fast rule that the skill and judgment possessed by these two persons must be the same? Both persons studied same degree, BCom or MBA or whatever the degree may be. Now, both are having same age, 23 years, and both studied same degree, same college. They belong to same village also. Then also you can't say that these persons are having same skills and judgment. Because it all depends upon the personal experiences, personal traumas underwent by the so-called person. So you can't judge like that. That is why you should not assign your office under any case. So a director must not means under any case you must not assign his office to another person. Such assignment is void ab initio, means void from very beginning. Void means void is a Latin word. Void is a Latin word. Void means what? Null or nil or giving zero legal effects. If an agreement is giving zero legal effects, that agreement is called as void. Void ab initio means void from very beginning. Zero from very beginning. Zero into anything is compliance. Compliance means follow. Compliance means what? Follow. Follow with the act. Which act? Motor Vehicle Act. Companies Act and articles. Which articles? AOA. Every company is having AOA, Articles of Association. What it talks about? AOA talks about how to do the business, how to execute the activities. AOA talks about. So compliance means board of directors must act in accordance with the AOA of the company and as per the provisions of Companies Act 2013. Are we clear? If any contravention is there, penalty 1 to 5 lakh penalty will. Okay. So tomorrow we'll discuss about powers. After that, we can go through the summarized tape and all. So do you understand 6 duties? First one is what? Act in good faith. Second one, exercise duties with due care. Third one, you should avoid conflict of interest. So you should avoid the situations which are causing conflict of interest. Fourth one, you should not achieve any undue gain. If achieved, you have to return to the company, refund. So fifth one, you should not assign the office. You must not transfer the office to any other person. Last one, compliance with the Act, Companies Act and Articles of Association. So these are the duties entrusted with the directors. Okay. Powers we'll discuss tomorrow. Okay. Right. Thank you.